So we have breaking news. In a 9-0 unanimous decision, the Supreme Court has said former President Trump can be on all state ballots for president. Let's talk about it. So former President Trump has been reinstated to all of the ballots that he's been kicked off of for the 2024 presidential election. But first, how do we get here? Initially, the state of Colorado kicked Trump off the ballot because they claim that he had incited and took part in an insurrection on January 6, 2021. Here is the news report covering it.
We've got some breaking news right now. The Colorado Supreme Court, get this, has just ruled on a challenge to Donald Trump's appearance on the state's 2024 ballot. I want to go straight to CNN's Paula Reed. Paula, what does this ruling say?
Well, this is a stunning ruling from the Colorado Supreme Court saying that Trump should not appear on the ballot in 2024. Now, this is surprising in part because they are reversing a lower court that found while Trump did engage in an insurrection on January 6, that Section 3 of the 14th Amendment did not apply to presidents, and therefore he should not be kept off the ballot.
Now, Colorado put their ruling on hold until the Supreme Court weighed in on whether it was even legal for them to do that. But while that case was pending, some other states also took liberty to kick Trump off the ballot, like Maine.
Breaking news tonight out of Maine, where a move by the Secretary of State has made Maine the first state to officially remove Donald Trump from the ballot on 14th Amendment grounds. In a ruling just moments ago, Secretary of State Sheena Bellows writes, quote, specifically, I find that the declaration on his consent form is false because he is not qualified to hold office of the president under Section 3 of the 14th Amendment. Bellows added, I conclude that the record establishes that Mr. Trump, over the course of several months and culminating on January 6, 2021, used a false narrative of election fraud to inflame his supporters and direct them to the Capitol to prevent certification of the 2020 election and the peaceful transfer of power.
And then most recent, the state of Illinois also declared Trump ineligible to run for president or be on their presidential ballots for the upcoming election.
All right, more breaking news. An Illinois judge has just ruled that Donald Trump should be kicked off the ballot in the state. The judge there in Illinois writing that Trump is not eligible to be on the ballot because of his actions on January 6th. That makes Illinois the third state, along with Colorado and Maine, to use the 14th Amendment's insurrection ban to remove Trump from the ballot.
Now, all of this legal reasoning and understanding came from the United States Constitution's 14th Amendment that simply states if you rebelled against the United States, or as it says here, engage in insurrection or rebellion against the same, the United States, you can't hold public office. But now the question for the Supreme Court was who gets to decide who engaged in an insurrection? Who gets to decide who engaged in the rebellion? Is it each individual state and with their own standards? Or do we have a national policy from Congress or from some federal agency that says, okay, this is what an insurrection or rebellion is that would make someone ineligible? So now, if you're an advocate of states' rights, then you would say, well, hey, each state should decide who's on their ballots. And that's what the states of Colorado and Illinois and even Maine said, right? This is just like abortion. Like how each state gets to determine their abortion rights, then each state should be able to determine who's on their ballot. Now, Trump team counted and said this is more like the freedom of religion, where you have a uniform basic policy across the country. The Supreme Court says this is what the policy is. Now, that's the floor, and all the other states have to follow what the Supreme Court lays out because it's federal law and the federal policy and the federal Constitution. And that is what the Supreme Court essentially said in this case. Now, let me take you back to the 14th Amendment. It has 5 sections in it, section 1, 2, 3, 4, and 5. Now, obviously, we're focusing on section 3 because that's the one that the states have said allows them to kick Trump off the ballot. But the Supreme Court said you can't look at section 3 in isolation. You have to look at it in the context of the whole amendment because the 14th Amendment has 5 sections. So section 3 does allow people to be disqualified, but who is allowed to enforce this section? Is the state of Colorado, is the state of Illinois, or is the state of Maine? Can they each individually enforce this against candidates in that state? And the Supreme Court says no. because if you look at the text of the amendment itself, it tells you who can enforce it. The Congress shall have power to enforce by appropriate legislation the provisions in this article. So it's clear that the state of Colorado doesn't have the authority to pass legislation to enforce the 14th Amendment. That's Congress's job. And if you have every state start passing individual laws to enforce this, then you can have a patchwork of different laws and stuff that wouldn't be uniform. And it would essentially be unconstitutional because the only authority given to enforce this constitutional provision is to Congress. Let's go to the ruling. So the bottom of page 12 for the ruling. For the reasons given that I just gave you, responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not the states. The judgment of the Colorado Supreme Court therefore cannot stand. All 9 members of the court agree with that result. Now, it's important here to understand what the court ruled and what the court did not rule. The court didn't rule that Trump committed an insurrection or that he did not commit an insurrection. It says that's not their decision. That's for Congress to decide what an insurrection is, how to enforce the 14th Amendment. That's all Congress. So in doing so, the court still left open if January 6th was an insurrection or not. Now, obviously, it all depends on what political side of the aisle you fall from. And, you have some states saying it is and some states saying it's not. But ultimately, it's Congress's job. And the court left that open. Now, the court, knowing how politically crazy this topic is, spoke to that piece of it. Here's Justice Amy Coney Barrett, who is writing particularly to give her opinion. She's writing a small 2-paragraph concurrence to give her opinion, but I think she sums it up best when she says this. The court has settled a politically charged issue in the volatile season of a presidential election, particularly in this circumstance. Writings on the court should turn the national temperature down, not up. For present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. That is the message Americans should take home. Okay, so let me just give you the bottom line. The court is saying, hey, Trump can be kicked off the ballot, but it has to be through an act of Congress and not each individual state. So when the states kicked him off the ballot, they actually violated the federal Constitution. Now, if Congress chooses to interpret the term insurrection and pass legislation to enforce it by kicking certain people off the ballot, Congress has the ability to do that. But since Congress hasn't done that, it's not up to each individual state to take that burden on for themselves. So this was my review of the Trump ballot case. Link is in the description to the full case. And if you like what you heard, don't forget to like, share, subscribe, do all that great YouTube stuff. My name is Nate the Lawyer, and I'll see you in the next one. Peace.